Tyler Robinson was back in court today. He's the man accused of shooting and killing Charlie Kirk. We'll talk about that. We will also talk about the very latest on the shooting at a Church of Jesus Christ of Latter-day Saints building in Michigan, including some interview with a person who goes to the church there, and also a man who had an encounter with the shooter just days ago, and he said it was terrifying. We will talk about that. And then the latest on Travis Decker. This is the father. We talked about this a little bit last week. We've been talking about it actually for a few weeks now, a few months. This is the man accused of killing his 3 daughters, and his remains were found last week. Well, someone we haven't heard from is the coroner who examined those remains. He's going to be here to talk about what they discovered. How did Travis Decker die? Will we ever know? We'll bring that up with the coroner who I chatted with earlier today. Before we get to that, let's talk about this guy, Tyler Robinson. This is the suspect who is accused of shooting and killing Charlie Kirk at Utah Valley University earlier this month. He had one court appearance a few weeks ago where he didn't have an attorney, and now he does have an attorney, and his attorney was with him, but he was not in court today. He appeared via video from the jail, but his legal team was there. The prosecution and their legal team was there. His attorney is a very experienced woman who has represented other high-profile cases, including the Ruby Franke case, and now she is representing Tyler Robinson. And they talked about how there is a lot of evidence that will be presented at this trial. The biggest takeaway for me, honestly, was the fact that they intend to have a preliminary hearing. Now, what does this mean? It means that when you are charged with a felony, in Idaho this is what it means, and I believe it's very similar in Utah. When you're charged with a felony, you have X amount of days, I think it's 21 days, to go before a judge, and the prosecution has to hold a preliminary hearing where they present just enough evidence to show that they actually have a case, that this person committed the crime, and then the judge rules if there is enough to advance the case to an actual jury trial. A lot of times, defendants waive this preliminary hearing. They just don't want to do it. They want to get ready for trial, and so they move forward, especially when there's a lot of evidence and in high-profile cases. Lori Vallow waived her preliminary hearing in Idaho. Chad Daybell did have his. It was a 2-day hearing in August. They called up witnesses. The defense doesn't have to present anything. They can cross-examine the witnesses, but they don't have to present any evidence. They don't have to present any witnesses. And this is what will be happening in the Tyler Robinson case. His attorney said that today. Here's a little bit of what the prosecution said.
The state is required to provide to the defense within 5 days of the defense's request the discovery that we relied on in making this charging decision. We'll be prepared to do that, so we'll look for defense counsel's request or the next day or so, and we'll provide that to the defense.
Thank you.
We also, for the court's information, we met this morning with the defense team briefly in our office to talk about discovery and the process. So we'll be working together. There is a substantial amount of discovery in this case, Your Honor. It's voluminous, to say the least, and we're working on a process where we can exchange information as quickly as possible and be efficient in that process. The other item I had, Your Honor, I saw that over the weekend, there was a protection order, pretrial and trial publicity order entered by Your Honor. And I just was seeking some clarification on page 2, at the end of the first paragraph. It reads, "To that end, lawyers participating in the investigation or litigation of this case shall inform all witnesses, investigators, consultants, staff members, or other members of the prosecution or defense teams that the prohibitions contained in this order." The state, we're seeking some clarification with respect to the phrase "all witnesses," Your Honor. There are a number of witnesses that have yet to be identified that will likely be used in the state's case. This occurred in front of 2,000 to 3,000 students at Utah Valley University. So we're in the process of identifying those witnesses. And so those individuals are presently unknown right now. So we're looking for a little clarification from the court. And I suppose we're not going to make any arguments today, but there may be some follow-up pleadings that we may need to file.
Thank you. Ms. Nestor, did you want to be heard about that issue?
No, Your Honor, we would defer to whatever the court wants to advise them on that matter. I mean, I think it's fairly obvious that we don't know who all the witnesses are in this case yet. I think it's just important that if anyone is identified, that they have information about this order. So I think other than that, we wouldn't weigh in on any other matter.
Thank you. Well, thank you for that question. That's an important one. The court will rule that as the witnesses become known to each side, that information is conveyed to abide by this order. Obviously, there are potentially many witnesses, and so it's not the expectation that you would be able to do that up front, but as they become known, I would ask that you would inform them of this.
So they were, of course, talking about witnesses, that the witnesses they intend to call can't be going around telling everybody, talking with other witnesses, things like that, especially when it's so high profile. Then the defense was able to say a few words, and here is what his attorney said.
So we are here today for a waiver hearing. It is not our intent to waive a preliminary hearing in this matter. We are going to be seeking that one be set. However, based largely on what the state just referred to as far as the voluminous nature of the discovery materials, we do think it would be prudent to simply reset for another conference, another waiver hearing, a little bit down the road, where we have a better idea once we start seeing the discovery as it rolls in. I do recognize we're going to be getting that first batch in 5 days, but it's my understanding from our meeting today that there is massive amounts of digital that is going to be coming. And until we can kind of get our heads around exactly what we're dealing with and how much we need to process, it's going to be difficult for us to give you a reasonable expectation of when we will be ready to do the prelims. So we're asking today that we put that decision off, and maybe we could check in 30 to 60 days and just kind of let the court know where we're at and how much we're looking at and how much time we may need to set a preliminary hearing.
Now, the judge did set the next hearing for October 30th at 10 a.m., and he mentioned that Tyler Robinson will appear in person. He intends to have them there in the courtroom. This, of course, will elevate security. Anytime there's a high-profile client, security will be elevated. There may be a lot of people that want to go down and actually see him and be in the courtroom. But we will see. We will see what that brings. The judge, it was interesting, Judge Graff, I think, did a good job laying out his expectations from both sides going forward. You might remember on the Koberger case, Judge Hippler, the first hearing he had with both sides, he laid out the line, like, this is how I run my courtroom, this is how it's going to be. That's kind of what Judge Graff did. He's only been on the bench 56 days. 56 days, can you imagine that? And now he has the highest profile case in the country, maybe in the world. Anyway, here's a little bit of what Judge Graff told both the defense and the prosecution.
As we are at the beginning of this case, it is my intent to only speak when I'm needed or it is necessary. But today I do wish to provide guidance and expectations that you can have for this court and wish to enter an order as well. As this case moves forward, Mr. Robinson's constitutional rights will be protected at every stage. He sits before this court presumed innocent, and that presumption remains unless and until each element of every offense charged against him is proved beyond a reasonable doubt. At the same time, and as applicable, victims are entitled under our Constitution to be treated with fairness, respect, and dignity, free from harassment or abuse. Justice demands that both of these principles, the rights of the accused and the rights of victims, be honored without compromise. I remain steadfast in my oath that I made 56 days ago to support and defend the constitutions of the United States and of Utah. I will carry out my duties with fidelity, transparency, and impartiality, treating every person who appears before me with the dignity and respect they are inherently due because they are human beings. Let me be clear. I will not put my finger on the scale of justice. These proceedings will be open to the public, conducted in accordance with the law, and handled with diligence and competence to ensure that justice is never compromised. It is the standing order of this court that Mr. Robinson shall be allowed to appear in person so he can fully engage with his attorneys and participate in these legal proceedings. Counsel, regardless of who is watching, whether it is the nation or a single individual, we must fulfill our roles with integrity, civility, and diligence. I encourage each of you to give your very best to this case. Neither Mr. Robinson nor the people of Utah deserve anything less than the fair and impartial administration of justice.
So now we again await that next court appearance. It's going to be October 30th at 10 a.m. We will live stream that, and we will bring you the latest as this case continues to develop and move forward. There'll likely be court filings in the next few weeks and months. I guess actually the 30th is a month away, so the next few weeks, and then we will see what happens with that case.